Respondent team, speaker 1 allocated time is 15 minutes and respondent team, speaker 2 5 minutes is an allocated time. So now we can start the proceedings. The court is in session now.
Whenever we reach to the bench, the counsel seeks permission to oppose the dice. Yes, much obliged, sir. May it please the honorable court, I am counsel number 1 appearing on the behalf of petitioner in the present case, Ravi Gupta vs. Union of Bharatmala and Tata Rock Private Limited. The counsel seeks permission to address the bench collectively at your lordship. Much obliged, sir. Your lordship, there are 4 issues involved in the present case. I will be dealing with the first 2 issues for 10 minutes and my co-counsel with the last 2 issues for 10 minutes. Would your lordship like a synopsis for the case?
3 facts.
If your lordship is well vested with the facts of the present case, then may the counsel seek permission to proceed with the issues of the case. Thank you. Much obliged, sir. Issue number 1. Whether the Public Safety and Data Management Act 2024 violates the right to privacy. Yes, sir. Yes, lordship. The Public Safety and Data Management Act violates right to privacy under Article 21. In Public Safety and Data Management Act, Section 3 of Public Safety and Data Management Act 2024 mandates collection of biometric info data, location history, and online activity from all residents without their explicit consent. In the Justice K.S. Puttaswamy case vs. Union of India, the Supreme Court laid down the triple test which need to be satisfied for judging the permissible limits for invasion of privacy while testing validity of any legislation. The 3 tests are the existence of law, a legitimate state interest, and law should be passed the test of proportionality. This law fails proportionality because it mandates indiscriminate data collection rather than targeting specific individual based on a reasonable cause. Section 4 of Data Management Act, Public Data Management Act 2024 allows private entity to manage sensitive personal data in a centralized repository. Private contractors might misuse or fail to protect the data, violating individual private rights. The Justice Puttaswamy case also said that the court also would that allowing private entities to manage sensitive personal data will lead to commercial exploitation of an individual's personal data without his consent and could lead to individuals court profiling. Section 6 of Public Safety and Data Management Act 2024 permits data sharing agreements with private entities without individual consent. The Justice Puttaswamy case also ruled that the law should have provisions for explicit consent and strict usage limitation before sharing data. There is tremendous scope for commercial exploitation of this information without the consent, knowledge of individual consent, and also for embarrassing an individual whose personal particulars can be made public by any of these private entities. If your lordship is satisfied with the argument, so far the counsel seeks permission to proceed with the second issue. Much obliged, sir. Issue number 2. Whether the denial of information regarding data sharing agreements, operational guidelines, and breach protocols infringe right to know under Article 19, Subclause 1, Subclause A. Yes, the denial of information regarding data sharing agreements, operational guidelines, and breach of protocols under Section 8 of the Public Safety and Data Management Act 2024 may infringe upon right to know under Article 19, Subclause 1, Subclause A of Indian Constitution. Section 8 of Public Safety and Data Management Act 2024 exempts all data sharing agreements from RTI disclosure. Blanket exception may be excessive as citizens should have access to non-sensitive parts of such agreement that impacts their rights. State of UP vs. Rajnarayan, the Supreme Court in State of UP vs. Rajnarayan ruled that the people of this country have a right to know every public act, everything that is done in a public way by the public functionary. They are entitled to know all the particulars of every public transaction in all its bearing. The Supreme Court in S.T. Gupta vs. Union of India ruled that no democratic government can survive without accountability. And the basic postulate of accountability is that the people should have information about the functioning of government. It is only if people know how government is functioning that they can fulfill the role of democracy assigned to them. and make democracy a really effective and participatory democracy. The citizens' right to know the true facts about the administration of the country is thus one of the pillars of democratic states, and that is why the demand for openness in the government is increasing.
So, Council, once you are talking about right to privacy and other, you are talking about right to know.
Yes, ma'am.
So, how have you, balanced out these two rights with reference to Public Safety and Data Management Act 2020? Because one issue is related to right to privacy, which is violation of Article 21, right?
Yes,
And the second is about right to know, which is a part of Article 19(1)(a) as quoted by you. So how have you balanced the rights of public and private in parties in this calculations?
Ma'am, as per S.P. Gupta and State of UP Kasaryan says that people have to right to know non-sensitive part of the non-sensitive part of the functioning of government. So if but in right to privacy, so.
You first you get from. You have adequate time. You take some water. You get from. Okay, no problem. You have good argument, good points. Take your time and then stick
Ma'am, your lordship, the government has right to store the data which are all data, but they have to disclose non-sensitive parts which does not violate, which does not influence national security or public interest. So. Ma'am, your lordship, the Public Safety and Data Management Act violates the three tests mentioned in Swami case. The existence of law is legitimate state interest. Law should be passed the rule of proportionality. If they does not violate proportionality, then this is valid. But in a right to know. But in the right to public has right to know after state of UP plus Raj they have to know not all the parts of the functioning of government, but those parts that are not sensitive. Those are not sensitive and those does not harm. That information does not harm the public interest, national security, or any of mentioned in law. They have a right to know. So this does not violate right to. So this violates right to know and right to privacy, because the Public Safety and Data Management Act does not disclose any information if it is sensitive or non-sensitive.
Okay, so your point is that sensitive data should not be disclosed.
Yes, sir.
And all other data are subject to right to information, and they can be disclosed.
Yes.
I believe I think what you want to summarize is this only. Can you again state what is the two basic points on which you are building your argument? Like as my colleague said, that your argument are 2 points. First, you are arguing for right to privacy.
Yes.
And again, your argument is on right to information, right to disclosure,
Right.
and that is also right of citizens. So, on what proposition, on what points you are balancing these rights? Or which right do you favor?
Sir, Public Safety and Data Management Act violates right to privacy.
So that's fine, Council. So one issue is related to right to privacy, which is violation of Article 20, wherein you are talking about individual's right? The other is about right to know, which is the right of every of a public to seek information. If not, then it is violation of Article 19(1)(a). Fine. My question is, one, you are saying it is violation of one person's right, a private right, and on the other way, you are talking about violation of public rights. How to strike a balance between both the things, both the rights?
By disclosing non-sensitive parts of the documents.
Fine.
Much better. Now I would like to call my co-counsel for further arguments.
Honorable Bench, the Council seeks permission to approach the rights. Greetings to Honorable Bench. I am counsel number 2. The petitioner approaching for the petitioner. The Council seeks you not seek permission to proceed issue number 3. Whether the PSD Act meets the constitutional requirement of proportionality is in balancing privacy and public safety. PSDMA Act 2024 fails to meet the constitutional requirement of proportionality in balancing privacy and public safety. According to Supreme Court judgment, Justice K.S. Swamy,
It's already clear. Where have you? Can you mention the relevant paragraph which you want to mention?
this is another compendium. In this case, the proportionality is an essential fact of the guarantee against arbitrary state to ensure that nature and quality enhancement of the right is not disproportionate to the purpose of the law. The main purpose of the proportionality is a valid law arise out of the mutual independence between the fundamental guarantee against the arbitration on the one hand and the petition of and the protection of the life and personal liberty. Without any justification, PSDMA Act collect the personal data. The state have also lacks individual consent of a specific grounds, making it unconstitutional invasion of the privacy. Section 6 of the PSDMA Act 2024 allows to guarantee to share collective data with the private entities without clear safe grounds. Section 11 of the PSDMA Act 2024 to provide complete immunity of the judicial review phase to balancing the test. Section 11 subclause 3 of the PSDMA Act 2024 provides for an internal affiliate mechanism within the NDSC. Internal review lacks independence and does not provide if Lordship is satisfied with the argument, so far the Council seeks permission to approach with the issue number 4.
Yes, proceed.
Whether the exclusion of judicial review under Section 11 of PSDMA Act is constitutional valid. Section 11 of PSDMA Act 2024 exempt the decision, directives and order of the National Data Security Council and NDSC for judicial review. The provision is unconstitutional as the violation the basic structure of doctrine and fundamental rights under the Bharatmala Constitution. According to the Supreme Court judgment L. Chandra Kumar versus Union of India, the judicial review is the basic structure of the Constitution's Article 32. Article 32 grants the right to move the Supreme Court for the enforcement of the fundamental rights, and Article 227 allows the High Court to issue writ against any government action violated legal or constitutional rights. In case 1 and Bharati case, the Supreme Court related the Parliament cannot take away judicial review through ordinary legislation. Section 11, subclause 3 of PSD Act provides for an internal appellate mechanism within the NBSC. Internal review lacks independence and does not provide adequate safeguard against the fundamental rights. If Lordship are satisfied with the argument made so far, the Council seeks permission to go with the prayer. The Council, in the light of the arguments, the appellant hereby prays that this Honorable Court declare the Section 3, 6, and 8 and 11 the PSD Act 2024 unconstitutional. Direct the argument to establish safeguard data protection safeguards. Thirdly, ensure judicial oversight over decision of NDSC. Fourthly, provide compensation to victim of the data lack breach. And fifthly, for any other relief this Honorable Court deems just and proper. Thank you, Lordship. I was indeed privileged pleading before the Honorable Bench.
What is your fourth last prayer?
Pardon?
Last prayer, you prayed for you made 4 prayers, huh? First, that to declare section 3, 6, 8 and
11 is unconstitutional.
then judicial oversight over matters of right to privacy. Any other, if you have. Since I will seek your permission to